Buenas tardes, bienvenidos. Mi nombre es Agustina del Campo, yo dirijo el Centro de Estudios en Libertad de Expresión, el CELE. Y antes de darles la bienvenida en nombre del CELE, voy a darle la palabra al doctor Fulvio Santarelli, que es el decano de la Facultad de Derecho, para que nos dé unas palabras de bienvenida en nombre de la universidad.
On the contrary, Agustina, thank you for organizing, hosting this important event. Thank you for your presence today here. As a School of Law, we are interested in these activities because they have sort of institutional importance. The objectives are basically three. That is to deal with topics that have to do with privacy, topics that have to do with a freedom of expression, values that are threatened by technological advance, and they have been highly dignified. But also we need to consider the tools that law can use to guarantee these laws. But we have a third topic to be concerned about, which is fascinating, is that
contemporáneo debe, es un análisis de eficacia de las herramientas que se elijan para garantizar la privacidad y la libertad de expresión. Si hay algo que la disrupción tecnológica ha causado en la comunidad jurídica en general, es una situación de perplejidad. No sabemos bien, la comunidad jurídica, cómo comportarnos en el diseño de herramientas para poder tener un desarrollo de las garantías constitucionales y de los derechos humanos acorde a los estándares que se habían planteado antes de la disrupción tecnológica. Así que una disrupción tecnológica garantizando los derechos humanos es una asignatura pendiente y me parece que foros como estos, que no solamente terminan en un debate o en un taller, sino que se le da continuidad a partir de las organizaciones que hoy están representadas acá, nos parece a nosotros vital para darle sustento a esta iniciativa, que no me cabe más que felicitarlos y bueno, y por eso nos hacemos partícipes también de ellos. Así que cuenten con nosotros, somos sus socios en lo que puedan considerar y adelante. Gracias por estar, gracias Agustina por traer esta actividad a la facultad que enriquece mucho las actividades nuestras. Muy amables.
Bueno, muchas gracias, Fulvio, por la introducción y por esas palabras. For English speakers, if you need translation, there's translation available, so please pick the aparatito. The headset. There. The receivers or headsets, that's what the official translation of that is. And you can pick them up outside of the room. So with no further ado, I'll give the floor to Vicky Bowman, and thank you so much.
Thank you. I would like to try and speak in Spanish, but I'm doing Italian on Duolingo, and my head is full of Burmese, so please excuse me for using English. So I am the chair of Global Network Initiative. I've been in that position for almost 18 months. And I took over from David Kay, and Agustina at the time was deputy chair. She stood down, but she gave me one instruction, which was to bring GNI to Buenos Aires, and we have followed that. So we are really delighted to be here. For me, my first time. My background is as a diplomat. I then worked in the mining sector in business and human rights. I have been based for a while in Myanmar, and that was where I developed my interest in digital rights. We worked on that in the period from 2013 until the coup in 2021 and until the military put me in jail. So I have always found the Argentinian experience of military coups very interesting and relevant and comparative to our experience working in Myanmar. I am very happy to be coming here to chair the board of GNI over the last couple of days. This is what has brought many of our company members, our NGO members, academic and investor members to Buenos Aires. We are a US-based non-profit organization. It was formed in 2008. And what we were set up to do is to work on promoting and advancing freedom of expression and privacy rights. And we have a particular focus on pushing back on overly broad, overly expansive government regulation in the tech sector and telecom sector, which could negatively impact on those rights. We aim to foster shared learning, accountability, and conduct collective advocacy on government and company policies and practices at the intersection of technology and human rights. If you go to our website, you will see many of the things we have done over the last 15 years, 20 years, almost 15, yeah, including many statements related to country-specific situations, but also to issues which are global and which are changing every day. We always seek to host an annual learning forum for all of our members and beyond to really share experience with other organizations, and we're delighted to be doing this with CELE today in Buenos Aires. It's our first annual learning forum in Latin America. Last year we were in Washington. Things are very different now. And indeed, that's really what the purpose of the discussions this evening is going to be. Many of the assumptions that we have had over the last few decades are changing. Many of the global geopolitical assumptions are shifting, and regulatory regimes are also changing rapidly and not always in a positive direction for human rights. So that's something which the two panels today will be talking about, and we will be focusing on how we can still see governments protecting human rights and companies respecting human rights against this background of these paradigm shifts. So we have two panels coming up. Agustina is going to be moderating the first. She can explain that. But then the second will be my GNI colleague, Min Aung, who will be looking at the implications for human rights of government regulation of AI technology. So that will be the second panel of the evening. And we will be pulling on speakers from our membership, from CELE members. CELE is, of course, a member of GNI. And we hope that we can focus globally, but also particularly given that we're here in Latin America, on what is going on in the region. So I'll pass back to Agustina. You've got your own microphone.
Bueno, y ahora sí. Les doy a todos la bienvenida. Muchas gracias por venir. Un montón de caras conocidas. Creo que hacen como 10 años que estábamos tratando de traer al Global Network Initiative a hacer la sesión en Buenos Aires. Y no es fácil. El Global Network Initiative tiene miembros de todas las regiones del mundo. Acá entre nosotros, porque somos poquitos y es una mesa chica, puedo compartirles que no son fáciles los procesos de visa para venir a Argentina. Es caro venir a Argentina. Muchas veces se hace muy complejo. Y en esa complejidad es mi agradecimiento por la disposición de venir hasta acá. Es más grande y espero que sea la primera de muchas otras. Les decía, les doy la bienvenida a todos, le doy la bienvenida a GNI y agradezco a Vicky, a Jason, a todo el equipo de GNI que organizó con nosotros este Annual Learning Forum y que incluso aportó para las sesiones del taller que empieza mañana. Este evento no es solo el Annual Learning Forum de GNI, sino que es el primer evento de nuestro taller anual. Estamos en la 13ª edición del taller. El taller nació como un espacio eminentemente regional. Empezó siendo un espacio de formación casi entre aquellos que trabajábamos libertad de expresión, sobre todo, en la región, y quienes trabajaban derechos digitales con una agenda que era mucho más chiquita que la que hoy ocupa gran parte de nuestros trabajos. Eventualmente, y con el correr del tiempo, los talleres del CELE se fueron haciendo más grandes, más diversos, más complejos en su temática. Y este año incorporamos, además de la perspectiva regional, una perspectiva internacional. Invitamos a académicos, a sociedad civil, invitamos a todo el grupo de GNI que vino a hacer su reunión de board aquí y que estuvieron trabajando ayer y hoy acá en la facultad, a acompañarnos en nuestras sesiones y a ver si podemos pensar, discutir, reflexionar los temas que nos interpelan como organizaciones, como académicos en el tema de Internet y derechos humanos desde América Latina, junto con otras organizaciones que están haciendo esto a nivel global. El hecho de tener conversaciones globales en el país de uno no es menor. En general nos sentimos como invitados a las conversaciones globales. Y poder invitar gente a la casa de uno a tener una conversación global creo que tiene un gustito distinto. Creo que los latinoamericanos que estamos acá dando vueltas sentimos como ese gustito de esta vuelta invitamos nosotros y esta vuelta vienen a casa. Que está bueno, que no es menor. Bueno. Thank you. I appreciate that. Les decía recién, el taller partió como un espacio de discusión, de reflexión. Invitamos cada año y convocamos cada año a los líderes de organizaciones regionales y a aquellos que están pensando esta temática para poder entender mejor las posiciones, para poder discutir las disidencias, para encontrar oportunidades de consensos, básicamente para entendernos mejor. En esta comunidad creo que es cada vez más importante, sobre todo atento el incierto presente que tenemos. Con eso en mente, los invito a pensar, a quienes participan del taller, los invito a pensar cómo hacemos que la discusión sea más interesante, cómo hacemos para que este no sea simplemente un intercambio de informes publicados, sino una verdadera reflexión y una discusión de fondo sobre los temas que nos convocan. A todos los líderes de organizaciones y a quienes están pensando esto, muchas gracias por tomarse el tiempo cada año de venir al taller del CELE y por priorizar este espacio y por hacerlo suyo. Las sesiones que tenemos en los próximos 2 días fueron sesiones que gran parte de esta comunidad propuso y que desde el CELE hicimos un esfuerzo de articulación para darles el espacio y la oportunidad de dar discusiones que sentíamos que era importante dar. Así que les agradecemos mucho su tiempo. A los líderes de las empresas que vinieron también, es importante tener a los headquarters de las empresas en casa, además de los representantes regionales que siempre son bienvenidos y con quienes trabajamos a diario. Tener a aquellas personas que se encargan de la política global de Internet, escuchando un poco la perspectiva latinoamericana, es particularmente importante. Así que gracias por participar y gracias por venir. A la Universidad de Palermo por el apoyo y por prestarnos todo el lugar, por facilitarnos la vida como centro de estudios, por promover lo que hacemos. Al rector Ricardo Popovsky, que nos acompaña en este evento, al decano, que nos dio la bienvenida. Y antes de empezar con los paneles voy a dar un agradecimiento enorme a mi equipo en el CELE, que trabajó los últimos 5 meses para armar esta semana de trabajo y realmente estuvieron en todo, en las jarras, las flores, las pantallas, repiten todo lo que va a suceder durante la semana, la logística, el camión de la comida, los conos, todo eso. Así que muchas gracias al equipo del CELE y bienvenidos a todos. So now, without further ado, the first panel that I have the pleasure of moderating. Bueno, tenemos un panel de lujo para empezar con esta tarde. Tenemos, bueno, ahí ven el nombre, Protegiendo los Derechos Humanos frente a nuevos marcos de regulaciones de contenidos. Las regulaciones de contenidos han visto que han proliferado a nivel mundial y comparado, han salido en todos los diarios. Pero la idea es hoy profundizar un poquito y ver qué se está viendo a nivel comparado y algunas tendencias a nivel global. La única que va a hablar español en este panel voy a ser yo, todo el resto va a hablar en inglés, así que de vez en cuando voy a meter alguna palabrita en inglés porque me sale, pero nada más. Tenemos en el panel a Usama, Bolo and Vice Chair of the Board of the Global Network Initiative. We have Logan Smith from Yahoo. We have Alex Walden from Google. And we have Zanatta from Data Privacy Brazil. They're all really good friends of mine, so I feel really among friends. Bueno, en América Latina los regímenes de responsabilidad de intermediarios tuvimos varias intentonas, veo a la gente del Congreso. Tuvimos varias intentonas por legislar responsabilidad de intermediarios y por ver un poco por dónde íbamos con la responsabilidad de intermediarios y nunca tuvimos un régimen específico de responsabilidad de intermediarios. Quizá llegamos un poquito tarde, quizá nos llevó mucho tiempo entender un poco, nos llevó mucho tiempo salir de la discusión de responsabilidad objetiva, responsabilidad subjetiva. Nos pasamos mucho tiempo en esa discusión. Pero fueron los tribunales, sobre todo, quienes empujaron la incorporación de un marco de análisis de derechos humanos a la lectura de responsabilidad de intermediarios y los que destacaron y eligieron enmarcar, a mi entender, sabiamente, la discusión de responsabilidad de intermediarios en el marco de libertad de expresión. Este no siempre fue el caso, no fue el caso en todos los países. En muchos países esto se enmarcó desde el derecho comercial y no necesariamente desde el marco de derechos humanos. En nuestra región los tribunales lo enmarcaron sobre todo en el régimen de libertad de expresión y desde ahí se construyeron los regímenes de responsabilidad de intermediarios haciendo un uso del régimen de responsabilidad subjetiva ordinaria de los códigos civiles de la región. A la luz de esto, me gustaría... ¿A quién le gustaría empezar? ¿Por qué no tenemos un orden? Así que me dicen a quién le gustaría empezar y yo disparo con las preguntas. Ok, empecemos por Usama. Contanos un poco cómo se ve la responsabilidad de intermediarios en Asia, en Pakistán, que es donde vos estás basado, y qué ves cambiando en este momento donde muchos de los presupuestos de responsabilidad de intermediarios están siendo interpelados y están siendo cuestionados.
Buenas tardes. Yo hablo muy poco español. So I'm going to speak in English. I have a translator on here. But I'm here to talk a bit about South Asia. And it's a small population, only 2 billion people, only a quarter of the world, no big deal. But yeah, as we see around the world, the governments are trying to bring in regulations, trying to hold intermediaries, responsible for a lot of this that happens. And we've also seen a huge shift towards laws that also put criminal liability on tech platforms for not acting in removal or restriction of content online. So we see this in India, where also, attempts were made to do this in Sri Lanka. And Sri Lanka is really a case I'll speak more about, but for context, similarly in Bangladesh and in Pakistan, there have been attempts to bring in similar laws. What we've also seen is that at the same time, with regulation, they're trying to penalize or criminalize fake and false information. For example, in Pakistan, the Prevention of Electronic Crimes Act was amended this year, in which sharing false information can get you in jail for 3 years and has millions of rupees of fine. So just the implications of that on freedom of expression, on press freedom. A lot of cases are being filed against journalists when they're critical of the regime. And we also, like Argentina, have a history of military dictatorships, and the military still has a lot of influence over politics and policy. So any critical speech is then penalized, and such laws are criminal. So I'll talk a bit about Sri Lanka, and it's a process that I've been engaging with as part of GNI. GNI has done a few statements in Sri Lanka in the past couple of years. So I'll walk you through a little bit on what happened. They brought in the Online Safety Act in Sri Lanka, in which they also tried to penalize sharing false information. It had a very broad definition of what an intermediary is. And that puts in, an unfair, it's not a level playing field. Because if you're a small tech platform, you're also an intermediary. But if you're, have a lot of compliance responsibilities and also a lot of penalties in case you don't act, it becomes very difficult for you to grow as a startup, for example. But the law also brought in heavy penalties on sharing of false information, on hate speech that was very vaguely defined, amongst other issues. But whereas it is very depressing in a lot of areas in the world, there's also a lot of hope. So the hope is in the form of protests, of people fighting back. And what we saw in Sri Lanka a couple of years back is that people came out on the streets and got rid of a very oppressive, democratically elected government, which was very, very corrupt. And then they had elections, and they elected probably the most progressive government that they've had in a while. And that's where GNI saw an opportunity that we should be part of the process, because that political party that is now in government had committed to bring reforms to the Online Safety Act. And that's where, we've been doing a lot of meetings with government officials. We've submitted in detailed recommendations on how to make the law compliant with international human rights law and framework, and commitments such as the ICCPR, talking about proportionality, necessity, and legality, the three-part test, and really inculcating those principles in the law that they have and how it should be amended. And similarly, now we've seen how in Nepal, social media has been used for young people to come out and protest, and in 4 days they were able to overthrow, a government that was seen as very corrupt by young people. But it's very interesting also what they did in Nepal. They elected their interim prime minister on Discord through social media, right? So it's a unique case where they elected the former Chief Justice of the Supreme Court as their interim prime minister, using, an app that's usually used for gaming and, other chat purposes. So we're also seeing a very evolving role of platforms now. And it raises a lot of questions that, are we going to have elections on social media now? And maybe that's what the young generation wants. And what does the future look like? So interesting questions for my colleagues on the panel. But to sum up, whereas there are efforts to bring in a lot of these oppressive laws, there is a lot of pushback. And in some places where you have very powerful governments, like in India or in Pakistan, it is not looking good for freedom of expression. But then the smaller countries where people are pushing back against it is giving a lot of hope to people in the region. So we're hoping that the governments are looking at these countries and learning from them. Thank you.
Alex? Great. How do you see global trends and intermediate liability from a very big company's perspective?
Thank you for hosting this session in particular, and thank you for giving us all an opportunity to come to your beautiful city and to the university. This topic is sort of evergreen and just kind of becomes more and more important, and it's something that we talk about inside companies all the time. We are a global company operating in every region that we are having a conversation about today. And so the types of regulations that are being proposed are things that have a very real impact on the day-to-day ways in which we operate our business and engage with our customers, and how we think about risks in engaging in other markets. But just to back up, Google's mission is to organize the world's information to make it universally accessible and useful. We believe that this is something that is critically tied to how much we want to advance the freedom of expression generally, and that is core to our corporate mission. We've always been committed to human rights and ensuring that that is something that is carved in how we think about content issues. And as we see the proliferation of regulations around the world, thinking about how we can frame a rights-respecting approach to the conversation is something that is important and meaningful internally in figuring out how to engage with governments directly, but also in the way that we engage in multi-stakeholder settings and ensure that we are engaging with our peers, as well as civil society leaders, academics, and responsible investors. So multi-stakeholder organizations have a big role to play in the conversation, both informing companies and informing governments about the opportunities and challenges of regulation. In particular, I think for us, one piece of it is about freedom of expression and our values around freedom of expression as a company. The other piece is that we really do believe that platforms brought unparalleled freedom of expression throughout the world and fostered economic growth in ways that are important. And individual companies should be focused on the impact of these laws. It's not just that we believe that. There is research that shows platforms help contribute to economies and have other social benefits. Of course, we recognize that there are potential harms that have been created by some of these platforms, and so we take responsibility for that and have created our own product policies to address those issues. But of course, there is also an important role for regulation. Also, when we think about intermediary liability, we think that that has been the baseline for why we have been able to create these platforms. And so we need to ensure that things like safe harbor remain, so that innovation and the freedom of expression that has thrived remain, while we look at ways to manage the risks that are obviously manifesting. Things that are important when we think about what does the regulation look like? That include things like ensuring that the way in which the regulation is tailored to the type of platform is meant to cover. So anything that is looking at how platforms should behave should take into consideration if it's a hosting content platform or if it's a platform like search where it's indexing information. Also, it's important, and we acknowledge there is a shared responsibility between what companies should be expected to do and then functions that are for governments. Companies should not be expected to take on the role of a court in society. And so we want to be clear about the role of the private sector versus other governmental functions. And again, things like notice and takedown are important, and governments have the responsibility to be specific about the way they provide that notice to companies. Last point I will add, because I know I've almost taken my 5 minutes, we also have concerns about the ways duty of care is articulated. When the duty of care in regulation is framed broadly and is vague, that creates tension for companies in how we're able to implement and comply with regulation, and it is likely that we will lead to overbroad enforcement. And again, that does not align with the priorities around freedom of expression. So, all of these things are in particular safe harbor and duty of care, are the things we should focus on in thinking about what the future of regulation looks like so that we, companies, are taking appropriate responsibility, but regulation is there.
Gracias, Alex, por la presentación. Y con el último punto que hizo Alex, que es como las nuevas regulaciones que vienen y la preocupación sobre el duty of care y este deber de cuidado que está apareciendo en la regulación de intermediarios a nivel mundial y que está ganando adeptos en distintos lugares. Le voy a dar la palabra a Rafa Zanatta para que nos cuente la experiencia en Brasil después de un cambio sustantivo de aproximación.
Gracias. Yo soy brasileño y yo viví en Italia, entonces siempre cambio las palabras con el español e italiano. Entonces voy a hablar en inglés para no hacer errores. It's a really tough task to explain what is going on in Brazil in 5 minutes, but I'll do my best from a civil society perspective. The first question should be like, what changed in 10 years since the enactment of Marco Civil, in which many of you were involved and you know very well? And for those who do not know, it's a federal legislation that establishes net neutrality principles, platform liability, freedom of expression, and privacy principles and rules. But how did we move from one platform liability regime defined by federal legislation on Article 19 to 4 different regimes that are now defined by the Supreme Court? This is a massive change in 11 years. And for those who do not know and want to know those cases in the Supreme Court, have a look, search on Google or DuckDuckGo or anywhere else you want, theme 987 or theme 533, and you will have the cases on the Supreme Court. And it's interesting because they started, one started as a small claim court case about fake profile on Facebook, and the other one started as a civil law case involving Orkut, the non-existing social network platform in which kids were calling a teacher ugly and unbearable, and therefore she filed a lawsuit for civil liability. And we should also bear in mind that there has been another big change in the past 10 years of a conjuncture element about what should be the legal regime. And so when the Supreme Court asked the questions, what should be the liability regime for platforms considering the duty to protect fundamental rights and democratic values ensured in the Constitution? That's the way they frame the question for the court. They're also thinking in other issues beyond those civil law cases. So this is one tricky part. And you must consider that Brazil in the past 5 years, we had first a federal law approved by Bolsonaro that defines what are the anti-democratic acts, so new criminal types against democracy. We had the January 6th event and the attempt coup against Lula in the first week of office by extreme right activists, extreme right-wing, to pass a legislation about platform regulation, in which there was a huge discussion about duty of care and what could be a separate legal regime for anti-democratic acts. So this failed attempt from the Congress to discuss duty of care, and the way also private sector and others blocked this federal legislation also leveraged the Supreme Court to use strategically this case to do something big and different, and in a way to create law. And this is problematic, and we should study that in detail. So the second point is from the civil society point of view, it's very different, the kind of opportunities you have for advocacy when you're comparing those two scenarios. So in one case, we had from 2007 to 2014, a lot of room for discussion and participation and building theories on platform liability regimes. It was a long process. In the second case of the Supreme Court, you have a very specific model of participation through amicus curiae, public hearings, and you need to work out your legal technique inside the procedures of the court. So that's a big barrier for participation as well. And I would say that in a nutshell, what happened basically was that the Supreme Court, they started out trying to really expand interpretation and set up a very broad liability regime, even strict liability. Then they changed to subjective models of liability, but they defined 4 different legal regimes. So one is when you have crimes against honor or civil cases in which you must follow the traditional Marco-Civil model. There must be a court decision. If you do not follow the court decision, then there is liability. The second regime is that they established for advertisement models and platforms that operate with a business model oriented towards advertisement. And there is this presumption of liability when you have profit in the advertisement. And there is the second discussion in the court when you allow like a network of robots or illegal acts within the platform. Third, you have then the adoption of the general notice and take down model for crimes, which is the Brazilian dialogue with DSA and the European model. And then you have the fourth model, which is quite unique, which is you have a model for really serious crimes. And I think this is the creation of Brazil in the Supreme Court, in which they say there is positive obligation, so there is positive obligation and duty of care for specific really serious crimes, like acts of terrorism, anti-democratic acts, networks of pedophily, and other types. And then there is this open question about what is systemic failure, which is an open question for activists and for the legal community, because they claim that even through one single case, like a civil law case, if you go to court and say, on this court, saying something really bad happened here, there is this network of young people trying to do something anti-democratic, and I want to say that there is liability of the platform, then the judge can say, yes, I can recognize a systemic failure, and then define the model of liability, even if it's a first level judge. So I think this opens really huge questions for all of us, like how to define the standards for what is systemic failure, how to protect fundamental rights of expression and avoid tragic consequences based on this new legal model. So I think it's for all of us, and I think not only Brazilians, all of us in the world, to study what happened in the Supreme Court in Brazil is really strategic, and to, in a way, protect and defend our values through what already happened, because we cannot overcome the decision anymore.
Gracias, Rafa, por compartir lo de Brasil. Fue realmente sorprendente la habilidad de la Corte para generar todo un marco, 4 marcos distintos. Esa parte es como impresionante. Logan, last but not least, certainly not least. Can you share with us a little bit of what you guys are seeing on intermediary liability? What are the best practices? What are the challenges?
Yes, and again, thank you, Agustina, for organizing and inviting us here. It's been a wonderful experience so far. I think it's helpful to contextualize a little bit. Many people know Yahoo. It's a recognizable name, but maybe we are not the largest internet platform or service, but we have a very long history, which I think is important. We were established before a lot of the intermediary liability regulations began, or the protections were established. For example, the United States' Section 230 protections came after Yahoo was created and operating. And so we have a very long view of the policy space and the trends that have been happening over time. And so we like to stay engaged, even though a lot of times some of the regulations are not intended to impact our company or the services that we're offering. I also think it's helpful to recognize where the regulation is often originating. Usually there is some event or something is viewed to be, a real harm that we need to address. And we recognize that in the human rights world, no right is absolute. So, the freedom of expression doesn't trump the freedom of privacy or other things. And so we need to take all this into consideration and recognize that, there is a right to safety and freedom from discrimination. And so a lot of the regulation comes with really, noble purpose, but the ends maybe are not what is, I guess, the best solution. And so I think we've been watching very closely, and I think agree with some of the things Alex has been saying about the ways that the laws are being scoped. And it's because I think that the process is a little flawed in that we see the issue that we don't like, the harm that is maybe being perpetuated, but then we skip to the desired solution or outcome, and we don't define the problem. Why is this happening? How is this happening? And really get into those details of exploring this issue with depth. That's why we have great academics to look at these issues, and bring that into the policy conversation, so that we could then develop the regulations that are going to be fit for purpose. But what we see most frequently is one jurisdiction taking, a first step or pass at something to address a harm, and then we see that idea spreading before it has actually been fully tested and evaluated to see if it is in fact effective or if it is creating any unintended consequences that need to be mitigated. And that spread has happened very quickly, especially in the online safety space. It's really hard to engage in policy discussions about online safety without coming off as an insensitive, soulless corporation that doesn't value children or some other vulnerable population. When oftentimes what we're saying is we value, safety and freedom of expression and privacy and the right to access information, and that all of this needs to be taken into account and balanced, and that there are ways to do that, but it needs to be, a more thoughtful process. So I think this is where we're approaching, I think, because we are not often, again, the intended target, but we find ourselves often in scope. We have to have a lot of conversations about, what is social media? How are you defining that? Does that include email? Does it include search? They seem very different in functionality, but in your definitions, they seem to be one and the same. And we see this in definitions in places like India, in their IT Act. How they define a social media intermediary seems to be inclusive of these other services. We've seen in Australia, for example, an Online Safety Act that creates broad buckets of services, like one of them called the Relevant Electronic Services category. I don't know what that is, but it includes email, private messaging, dating apps, and gaming. And they all have the same expectations, but they're all very different services. And then we see that definition from the Australians popping up in Singapore. And those jurisdictions have very different cultures and views towards human rights, or how they operationalize things, or how their politics work. And so that policy contagion is really troubling at times, especially when some jurisdictions that like to present themselves as more rights upholding than others are the ones that are in fact creating the policies, which are then being spread to other locations, which are actually causing real harm. And so I think we're really invested in trying to find ways that we can participate in these conversations, to share perspective. I think, just as much as we value the multi-stakeholder approach to, human rights is what we do in the GNI. I think in the policy space is finding ways to have more multi-stakeholder collaboration, that is actually working together and less oppositional, would be a great way to move forward in that space.
Bueno, muchas gracias, Logan, por la intervención. Es interesante, ¿no? Desde el CELE miramos cómo migran algunas leyes o algunas políticas y es bien interesante cómo propuestas de ley que surgen de repente del otro lado del mundo aparecen en algún país de la región, casi literales en muchos casos, con instituciones radicalmente distintas, con organismos distintos, con culturas jurídicas distintas, incluso hasta muchas veces de jurisdicciones con más de civil law y que traen cosas del common law y las mutan con una naturalidad que da mucho miedo, para ser muy honesta. Pero bueno, tenemos media hora para para preguntas de todos ustedes sobre responsabilidad de intermediarios y cómo esa responsabilidad de intermediarios está cambiando. Yo sé que es un tema que venimos hablando hace un montonazo de años, ¿no? Pero las condiciones, las formas de hablar de responsabilidad de intermediarios creo que cambiaron dramáticamente. Así que a mí se me ocurren un montón de preguntas, pero antes de que me toque a mí, les voy a dar la palabra a ustedes, porque lo que me pasó en los últimos paneles en los que participé es que yo pregunté y después nos quedamos sin tiempo. Entonces, voy a optar por democratizar la pregunta en lugar de monopolizar el micrófono. Y con esto le aviso a la gente que está grabando que estamos por concluido el panel.